of pets in housing, pets, service animals, and emotional support is I want to distinguish the three categories of animals and emphasize for you that those are three distinct legal categories. And we're going to go through this afternoon each of those categories and how the law addresses them. But generally, tenants do not have protections against landlord restricting pets in housing, in private housing situations. And there are some exceptions to that. So we'll talk about that. And then the other issue is that generally service animals cannot be excluded from housing, but there are some special requirements that apply. And then finally, emotional support animals actually have the most legal protections and the fewest restrictions can be put on them by landlords. So, what are common household pets? We have some cute pictures here of some puppies and a mouse and a parrot and even a lion and lioness. And actually, those are not common household pets. Dogs, cats, hamsters, rabbits, guinea pigs, birds, all of those things are considered common household pets. And there are about 20 to 30 commonly recognized household pets. But you probably cannot have certain deadly snakes, spiders, and other crawly type things as a household pet. There is a list, and we'll get to that later. But private landlords do have the right to restrict pets in housing, and it's usually done by your rental or lease agreement. If you have a lease or rental agreement, you should check to see if there is a pet addendum attached to it and whether that pet addendum has breed and weight restrictions and the types of animals that your landlord bars in that particular living situation. And so I'm going to show you an example of a lease provision. This paragraph 14 says animals. And under this lease, this is a very current lease that is used by one of our well-known California property managers, FPI Property Management. They have very large complexes all over California. And this is a sample of one of their lease provisions that says no animals are permitted without prior written consent of the owner. And that consent may be revoked at any time, with or without cause, by giving 10 days written notice to the tenant. And if you don't follow the written permission, then any animal that is brought upon the premises, whether that animal belongs to the tenant or even their guest, that it says if they're just visiting, that is deemed a material breach of the rental agreement and is cause for service of a notice terminating the tenancy. So this is considered a material clause of the rental agreement. And if a tenant breaches it, the landlord is telling you that's cause to be evicted. And it says that this policy specifically does not apply to accommodation or service animals. And it says that if you're a disabled person who requires reasonable accommodation, then you should contact the landlord and they will comply with the applicable laws related to reasonable accommodation. We're going to talk about that in a few minutes. So this lease not only has this clause 14, but it also has a restricted animal breed list. And this, if you look at this, there are a lot of dogs that are not allowed, dog breeds. Most of them are wolf breeds, and you see any wolf hybrid or any hybrid or mixed breed of one of those breeds. And some of these are some really nice dogs, like, I wouldn't mind having a husky or a Malamute or, but we know about pit bulls and Rottweilers, but St. Bernards can be great, Staffordshire Terriers, but this particular management company does not want these dogs in their community. And they don't want poisonous animals including tarantulas and piranhas. And they also don't want exotic animals such as ferrets, skunks, raccoons, squirrels, rabbits, or birds such as parrots, cockatiels, and macaws. So this list is pretty extensive of what this landlord is restricting from the community. But you see the bold note, service and companion animals may not be subject to this list. So if you have an emotional support animal that is one of these breeds, you may have an argument that you are entitled to keep this animal as an emotional support animal. We'll talk about that later. And then not only is there the restricted animal breed list in this rental agreement, but it also has the animal addendum. And unfortunately, I didn't make it 100% when I saved it to this PowerPoint. But I will just say that if you have an animal addendum, you should read it carefully, because it says that no pets have been authorized at this time. You see on this particular lease, there is no pets authorized. But if there had been, it would be listed there. And then you see that there's a deposit for the rent for the pet, and there is rent for the pet, and there are community restrictions. There are maybe inoculations required, and a clause that tells you if your animal is disturbing other tenants, that may be breaching the covenant of quiet enjoyment in your lease, and you cannot have a pet that disturbs the quiet enjoyment of others. And then this also talks about liability. So if you have a pet, you may want to have renter's insurance, because as it says here, now this one is big enough to see, the residents, household occupants, guest invitees are liable for damages caused by the pet. And it says here too that the tenant agrees to indemnify and hold the landlord harmless for any activity or damage caused by that animal. And also it says here, if you violate these rules, they could charge you $25 per occurrence as a liquidated damage, but they still could try to terminate your tenancy, force you to remove the animal, or evict you based upon the violation of this addendum. So you can see here that this landlord in this lease is attempting to nail it shut, to let you know that tenant, no animals unless they are service animals or emotional support animals, and you have received permission to have them in the community. Okay, so let's talk about assistance and service animals, the second category, because we were just talking about pets as common household pets. The law says that service and assistance animals are not considered common household pets for the purpose of applying the law. And service and assistance animals are specifically defined in the Americans with Disabilities Act, which is the federal law that requires landlords to provide reasonable accommodation in housing. And so here you'll see the definitions, excuse me, and assistance animals can be service or assistive animals that someone with a disability needs in order to use and enjoy their housing. And I like this example of signal dogs. If you think about a hearing impaired person, they're disabled because they can't hear. And so there are animals that can be trained to alert the tenant when the phone rings or when the doorbell rings. And those animals are specially trained to help a person who is hearing impaired. And so that's a good example of an assistive animal. Then a service animal, most people know about these, are specially trained to do work or to perform tasks for the disabled person. And a good example are seeing eye or guide dogs, who help visually impaired people walk down the street or navigate their life. Those dogs are specially trained as well. And you may see them, the picture here on this slide shows the type of collar that they wear or harness that says service dog right on it, so that the public knows that that person is disabled and is being assisted by that service animal. So other assistance animals perform tasks, assist, or provide emotional support for a disabled tenant. And those animals do not have to be specially trained. There are no regulations governing what they're supposed to do or how they're supposed to behave. They do not have to be licensed. They're providing emotional support for a disabled tenant. And really, the tenant is disabled by virtue of their emotions. They've been diagnosed with some condition, and their therapist or doctor says they need the dog or cat or emotional support animal to make them feel better. So that's how the law defines the three categories that we're talking about today. So let's talk about the actual laws that apply. In federal law, under federal law, um, landlords cannot discriminate against tenants who come to them with a pet if they are disabled. And that's under the Fair Housing Act, 42 USC section 3601, etc., describes the rights and prohibitions for landlords in housing when tenants come with pets or service animals or emotional support animals. And the Fair Housing Act does provide for reasonable accommodation, and it requires landlords to provide accommodation for service and assisted animals and emotional support animals. The Americans with Disabilities Act, a lot of people know about the ADA. That's found at 42 USC section 1201, etc. And that law also provides the definitions of service and assistive animals and states where they are allowed, how they're allowed to be controlled, outlines the invalid policies that some landlords tried to use governing animals. And it also provides some guidance for landlords to enforce the Americans with Disabilities Act in their housing situations. And this is another federal law for 12 USC section 1701 R through L. This specifically is a housing and urban development related law because it applies to most of the federal housing programs, including the rural housing programs under the U.S. Department of Agriculture. All of the federal housing programs are required to follow these rules regarding animals. And that law prohibits landlords from requiring deposits, rents, or insurance for service or assistive animals. It provides reasonable accommodations for persons with disabilities and prohibits discrimination against applicants who are coming in with common household pets. 42 USC section 1437 Z through C is another federal statute that covers conventional public housing and gives regulations for pets. It also provides for reasonable accommodation in public housing, and it specifies that assistance animals for the disabled are not defined as common household pets. Another law that many of you may have heard about, Section 504, some of you may have heard about this because it also governs special education in special ed, the rights of disabled students. But the Rehabilitation Act of 1973, Section 504 here allows service animals in housing that receives funding from the U.S. Department of Housing and Urban Development. So it applies to most federal housing programs, again, including the USDA housing, and prevents discrimination against those who need emotional support animals or housing applicants who need service or assistance animals. And again, the same thing, prevents deposits, rents, or insurance for service and emotional support animals. The only prohibitions are that the pet cannot be a danger to the health and safety of others. And that's why things like piranhas and snakes and lion cubs and leopards and panthers are a health and safety hazard, and there are also health and safety codes prohibiting you from having those type of animals in housing. And also it's valid for the landlord to charge you if that animal causes damage. One quick note too about housing, public housing authorities, PHAs. The HUD regulations grant public housing authorities around the state the discretion to establish the pet policies in federal housing programs. And those policies are required to be reasonable and conform to local law. You can find those policies in your public housing authorities annual plan that is required to be published online by every public housing authority in the country. You can find their plan and you can find the policies that exist for that particular housing authority. But one caveat, there was a case that said removing a pet's vocal cords is not reasonable. Someone tried to get a person to take their vocal cords out of their dog's throat because they barked too much, and the court said that is not a reasonable policy. Here's another law. Now we're talking about state law that applies to pets in housing, and the California Fair Employment and Housing Act, you may know it as FEHA, Government Code Sections 12955 to 56.2, applies to all landlords and housing providers in the state of California, and it prevents housing discrimination. It also provides for reasonable accommodation like the federal law does, the ADA, and it again prevents deposits, rents, or insurance for assistance and service animals. And again, they can't be a danger to health and safety of other tenants, and you have to pay if they cause damage. Same exact thing under the Unruh Civil Rights Act, which is found at California Civil Code Section 51. That provision prevents housing discrimination and requires reasonable accommodation for people who have disabilities. This Unruh Civil Rights Act is very good because it specifically is designed to have tenants who are disabled have, quote, full and equal access, end quote, to all of the housing accommodations, not just their apartment unit, but they have to be able to access mailboxes, laundry rooms, common areas like the clubhouse, the pool area, etc. And if they have an emotional support animal, they have the right to have that animal accompany them to those housing accommodations. And some landlords want to try to prevent disabled people from going to the pool with their dog, and they cannot do that under the Unruh Civil Rights Act. A little known, we have a California Disabled Persons Act under Civil Code Section 54.1, and that has those same prohibitions against housing discrimination. And it says that every individual with a disability has a right to a guide dog, a service dog, or other specially trained animal, and you can't charge for it in any way. This is a little known law that we have in California, the Food and Agriculture Code, Section 3850. 30,851. That covers the regulation and licensing of dogs, and it also talks about the licensing of specially assisted dogs, guide dogs, signal dogs, and other types of specially trained animals that assist the disabled. And again, no rents, no deposits, no insurance. And so you see that all of the laws I've just talked about carry almost the same provisions for disabled people to have reasonable accommodation in housing, to have their service animals, or to have their emotional support animals with them in housing. And so now we get to talk about a couple of the cases that have been decided under the pet policies Especially these are mostly cases in the Ninth Circuit or in our neck of the woods, our Court of Appeals or our Ninth Circuit, the Supreme Court of California. But this first case, Woodside Village versus Hertzmark, is a Connecticut case that was decided in 1993 by the Supreme Court. And in that case, the court upheld the eviction of a disabled tenant because even though the landlord's policy was reasonable, and well, because the landlord's policy was reasonable, and that landlord had made attempts to accommodate the person's disability, but it was shown that the disabled tenant was not even able to control the guide dog. And so the court said that the landlord made reasonable efforts to comply with the law, and the tenant needs to be able to control that animal. That was the holding of Woodside. In Fair Housing of the Dakotas versus Goldmark, that was a North Dakota case in 2011, where that court denied a motion for summary judgment where the realtor was trying to say their policy was good. The court said it wasn't. The court said that that policy raised issues of disparate impact on people who were disabled, and that it was a failure to make reasonable accommodations for animals who were not specially trained under the Fair Housing Act. So that case was decided under the Federal Fair Housing Act. There's also Green. This is a good case, Green versus Housing Authority. That was against the Public Housing Authority in Oregon. I always talk about housing authority, but no, Oregon Housing Authority would not allow this mother and her deaf son to keep their dog as an assistance animal as a reasonable accommodation. And they had no reason that they couldn't give the court any reason why they didn't want to let this deaf boy have his dog. And the court said there was no impact on the defendant housing authority. Why did they care if the dog was helping the deaf boy? And so the court granted them summary judgment in their lawsuit, and they won. The last case is Auburn Wood One Homeowners Association versus the Fair Employment and Housing Commission. That was in 2004, and that's in California. And this is a Court of Appeal case where the Fair Housing Commission wanted to accommodate a resident who had a small dog that helped her with her depression, and they wanted to accommodate her. The trial court in California said, no, we won't accommodate her. And the Court of Appeal overturned the trial court, saying that that was a wrong decision under the State Fair Employment and Housing Act, that they should have allowed that resident to have the small emotional support dog. So here you see a variety of cases that deal with a private landlord, a public housing authority, a reasonable accommodation under the Federal Fair Housing Act, and a case under the California State Fair Employment and Housing Act. Each of those cases is precedent, and there are some more current cases that have been decided. I just did not get a chance to update this PowerPoint to put them all in here, but yeah, there are some newer cases under the ADA and under the California Fair Employment and Housing Act where landlords have been sued for failure to make reasonable accommodation for people with disabilities. And so here, I'm providing you with some tenant resources if you feel that you want to look into whether your rights have been violated to either having a service animal or an emotional support animal or even a pet. You can look at the U.S. Department of Justice website here cited. They have a guidance on service animals for the Civil Rights Division of the Department of Justice. And then you'll see here Housing and Urban Development has the Public Housing Occupancy Guidebook, and that guidebook discusses pet ownership in public housing. You can find that at www.hud.gov. And then you'll see another HUD website for assistance animals, which is HUD's guidance on assessing a request for animals. So this is really a guidance for landlords. They have no excuse for not knowing how to address a request for a reasonable accommodation for an animal. The guidance is right here. And if a landlord is getting federal assistance or federal tax credits or whatever from the federal government, then they need to know this law so they can comply with providing reasonable accommodation to tenants. And then also see the Fair Housing and Employment Office of HUD. There's the local one in Northern California is in San Francisco, but you can go on HUD's website to find your local Fair Housing and Employment Office. They issued a notice in 2001 about assessing a person's request to have an animal as a reasonable accommodation under the Fair Housing Act. And it gives guidance on what landlords are supposed to do and what they're not supposed to do. Disability Rights California is an excellent resource for anyone who has a disability or has any questions about rights as a disabled person. And there are so many good resources on this website for all topics related to disability law. But their website does have some good fact sheets on the rights to assistance animals in housing. So in summary, I just want you all to use these resources, use the Sacramento County Public Law Library if you need to. They have lots of resources there. They also have the NOLO books, which are in layman's language to help lay people understand the law well. And as I told you earlier, the reference librarians there are priceless for getting to the root of your legal problem. And even though they can't give legal advice, they can point you in the right direction. They are very good librarians there. I love my Sac County Public Law Library and the one in Oakland too. I mean, there's some good law libraries around the state, but Sac County Public Law Library is really good. So we've told you that you can contact us at HERA. This is our website, heraca.org. If you want to go on our website and tell us about your problem, or if you want to, oh, what happened? Sorry about that, people. If you want to go on our website and make an inquiry, our admin staff will set you up with an attorney. You can call this number 510-271-8443, extension 300, and someone will call you to get the details of what your legal problem is and get you a consultation with a specific attorney on our staff. And there you see my email address. If you have any questions you want to send to me, I'm amerritt@heraca.org. And I really thank you all for your attention this afternoon. I hope this webinar has been informative, and I hope that none of you are trying to have these chocolate bunnies as your assisted animal. That's just a little joke, but thank you for your attention, and let's see if we have any questions that need to be answered today. Oh, right. And let me remind you, please do not forget to fill out the survey that you see in the chat box on SurveyMonkey. And please also give me your questions. Okay, let me look at the Q&A box. There's a question asking, where can a person have a lion cub? There are some rural locations in the country where you can have a lion cub, but actually there are lots of health and safety, and I think I gave you the California reference for the agriculture code that governs regulation and licensing. And one of the things that I realized I did leave out of this PowerPoint presentation is local ordinance. I totally skipped, I did state and federal law, but every person should check whether their town or city has a local ordinance that specifies regulations related to animals, because I recently discovered that the city of Los Angeles has a different local ordinance than Culver City, where you can have 5 cats in Culver City, but you can have 8 in Los Angeles. And so, you really need to know what your local ordinance says about the right to keep animals. And there are very many local ordinances that prohibit other than common household pets. And lions are considered health and safety hazards and dangerous, especially when they get to the point that you can't feed them enough of that meat that they like to eat. And now we have a question. If a landlord requires all tenants to obtain liability insurance to move in, does the tenant with emotional support animal have to obtain the insurance? Yes, and the reason I say yes is because the requirement for liability insurance in most of these common leases in California these days, and the leases are very extensive, pages and pages long. Many of the landlords are sending them to you electronically because you do have to pour through all of those terms. And normally the insurance clause in these leases is requiring you to have insurance to cover your premises, your belongings, and any negligence or damage that you cause. That's insurance for you, liability insurance. That might not cover if your dog causes some damage, and that's a matter of your insurance company whether they even insure for damage that would be caused by your dog. That's a different issue. And when I'm talking in this PowerPoint about the prohibition, some of the leases say that if the animal clause that I showed you today was we recommend you get insurance for the pet for in case the pet causes damage. That's pet insurance. And these laws that I reviewed with you today specifically say that if it's an emotional support animal, the landlord cannot charge you separately, make you have separate insurance, can't charge a separate deposit, can't charge separate rent for the emotional support animal. But if all tenants have to have liability insurance, that's liability insurance. And yes, you must have that if your lease requires it, because most of these landlords now will charge you for it if you don't get your own. And theirs is more expensive. You can go get a $6 a month liability policy as an apartment renter and have your own insurance and not pay for what that landlord tries to charge. Someone is asking what jurisdictions does Housing and Economic Rights Advocates assist in? We are in the state of California and we cover the entire state. We have attorneys all over the state, and right now we're focusing a lot of our work in the Central Valley of California. Sacramento is a big area that we've moved into. We do a lot of work in the East Bay, in Oakland and San Francisco, the South Bay, Fremont. But anywhere in the state of California, we will give you advice on landlord tenant law and many other areas that we assist with. We have an estate planning team, not a team, but we have estate planning advice. We do foreclosure prevention. We do a lot of things. HERA exists to try to provide assistance to people on economic issues to improve their economic picture. So debt and credit issues, solar panels, Our whole goal is to, we're a nonprofit, and our goal is to help low and moderate income residents, tenants, homeowners, and homeless residents to try to address rental problems, preserve the family home, understand student loans and options for college, fight abusive mortgage problems, get loan forgiveness and try to manage loan debt, to set up an estate plan, and to try to understand your rights across a whole spectrum of household debt and credit issues. So that's what we do, and we do it in California. If you're in another state, we are on a listserv with attorneys all over the country for all of the specific areas that we work on. Someone asked, do these laws apply to public buildings and spaces like our senior center? Yes, they do. And as I discussed under the state and federal laws, if it's a public building, it's probably subject to the federal Fair Housing Act, which requires reasonable accommodation, and it requires people with assistive animals, service animals, and emotional support animals to be allowed into public buildings and spaces. And they cannot be prohibited from entering with their supportive animal. Someone asked, are there laws around multiple emotional support animals? Oh, that's a really good question. And that's a question I haven't researched. But you know what it really would involve is, a request for reasonable accommodation under the Americans with Disabilities Act or the California Fair Housing Act. You're required to provide some type of letter from a doctor that says you need that emotional support animal. So I could envision a situation, Yesenia, Miss Rubio, if you had multiple emotional support animals, your doctor might say that that's what you need as an emotional support. And so it really has to be justified by the doctor. The doctor that's what really ties the accommodation to your condition, is what your doctor says it is, and says that you need that emotional support. And that's why the landlord has to provide it, because it's been certified by a physician or a therapist or a counselor or somebody who says, yes, you need those animals to make you feel right, to cure your depression. The next question: if a dog causes personal injury like a bite or scratch, will my dog be taken away from the owner and put to sleep? This is probably what I was saying earlier, local ordinance, because there are local ordinances that govern dog bites, and there are lots of dog bite statutes around the state of California. I didn't go into any of the dog bite statutes because in housing, the lease tells you that if your animal causes injury or damage, that you could be evicted, and that but um, it's up to the public health department or animal control as to whether that dog is going to. And normally, I think I haven't done any dog bite litigation since the early 90s. But when I did look at the California dog bite statute, and you get 2 bites in California. And after the second bite, your dog is going to be put to sleep by animal control. Now, I haven't looked at that recently, but animal control in your city can answer that question better than I can. And probably the dog bite statute, which I haven't looked at recently, can answer that question. If your dog bit someone more than once, the answer is probably yes, from my knowledge of the law. And so, yeah, if your dog had, because they talk about the propensity, like pit bulls aren't allowed because they have a serious propensity to bite and to turn on their own owners and bite people. And so, if a dog has bit someone before, it might be a dangerous dog and have a propensity to bite people. And you don't want to be having that type of animal, and animal control will put that animal down. if it's more than one bite. So I hope that answered your question. Do we have any more? No, it doesn't look like we do. So I want to thank all of you who participated today. I do know that this webinar you can see again on the Public Law Library website, and you'll also be able to access it on HERA's YouTube channel. It will be available publicly. And I believe that our administrative assistant, Michael Sun, can send you the PowerPoint presentation if you would like it. Thank you for the comment, Mallory. Very informative. I appreciate it. And you all have a great rest of the day. And we will see you at our next Ask a Lawyer series, which is next week. I will be talking about the rights of domestic violence survivors in federal and public subsidized housing. So join me for that and have a great week. Thank you. Bye.